You know, deep inside Canada's constitution, there's this one single clause that's so powerful it can actually override our fundamental rights. It's called Section 33, or the Notwithstanding Clause. And depending on who you ask, it's either a huge threat to our freedoms or it's a vital part of our democracy. Every single time it gets used, it kicks off this massive national debate.
I mean, just think about this for a second. What if a government, one that you elected, passed a law that a court then finds violates a fundamental right guaranteed in the Constitution? And what if that same Constitution had a built-in mechanism that lets the government just turn around and say, yeah, we're doing it anyway? Well, that's the incredible power and the huge controversy at the heart of Section 33.
So, to really get to the bottom of this, here's how we're going to break it all down. First, we'll get into what this constitutional override actually is. Then, we'll look at the main argument against it, the idea that it's a threat to our rights. After that, we'll explore the other side, the built-in safeguards, like democratic accountability and this 5-year clock. And finally, we'll dig into that really fundamental question. In a democracy, who should get the last word?
Okay, so before we can get into the heated debate, we have to nail down the basics. What exactly is this constitutional override? Well, putting it simply, Section 33 gives the federal or provincial governments the power to pass a law that works in spite of the fact that it might violate certain rights in the Canadian Charter. It's kind of like a legislative trump card. And the government has to come right out and expressly declare they're using it. It's not something they can do by accident.
Now, this is absolutely crucial. The clause doesn't apply to everything. It can be used to override fundamental freedoms. Think expression, religion, plus legal rights and equality rights. But, and this is a really big but, it cannot be used to override our core democratic rights, like the right to vote or our mobility and language rights. The people who wrote the Charter deliberately put those specific rights in a protected zone, seeing them as essential to how the country even functions.
And that power brings us right to the main criticism. I mean, if a government can just override rights, what's the whole point of having a charter in the first place?
The biggest fear here is that the Notwithstanding Clause basically pokes a hole in our rights protections. Critics argue that it gives whichever party is in power the ability to strip away protections from minority or marginalized groups, the very people who rely on the Charter as a shield. It feels like it puts our most basic rights at the mercy of political winds.
This quote from Professor Françoise Charon just nails it. The idea is that, sure, politicians can have the last word on regular laws, but our most fundamental rights and freedoms, those should be locked down in the Constitution, for the benefit of the doubter, for anyone who might not trust the goodwill of the majority. They need a guarantee that's totally beyond the reach of day-to-day politics.
But of course, that's only one side of the coin. People who support the clause say it's not some dangerous loophole. They see it as a feature with its own powerful built-in checks and balances, and that starts with democratic accountability. You see, the first check isn't a legal one, it's a political one. Using the Notwithstanding Clause is a huge deal politically. It's guaranteed to create, as the sources say, significant political flack and a very real political cost. A government can't just sneak this through. They have to stand up in public, explain exactly why they think overriding a fundamental right is necessary, and then deal with the fallout from voters, the media, and everyone else.
And this gets to the core democratic argument for the clause. Think about it. Judges are appointed, but our legislators are directly accountable to us, the people. If a government uses this clause in a way that the public just completely rejects, the ultimate check is right there at the ballot box. We can just vote them out. It puts the final authority in the hands of the electorate.
And there's another major safeguard, one that's written right into the Constitution itself, a really strict time limit.
That's right. Anytime the Notwithstanding Clause is used, it automatically expires after 5 years. It's often called a sunset clause because, just like the sun, the Declaration has a built-in end date. It can't, on its own, create a permanent change to our rights.
So here's how that actually works. A government makes the declaration. It's only valid for 5 years, max. Once that clock runs out, it's done. The Charter right snaps back into full effect, unless the government is willing to go through that whole political firestorm all over again by actively reenacting it. This forces the issue back into public debate over and over.
So when you put all of these pieces together, you get to the central philosophical wrestling match that Section 33 really represents in Canadian democracy.
It really boils down to two competing ideas. On one side, you have the idea of a judicial final word, where courts interpret the Constitution and have the power to strike down laws that don't fit. And on the other side, you have the idea of a legislative final word, where our democratically elected politicians can, in very specific cases, have the final say. Section 33 is the tool that makes that legislative final word possible. And it's so important to remember this wasn't an accident or some kind of oversight. The sources make it crystal clear that the framers of the Charter put Section 33 in there on purpose. It was a deliberate compromise designed to balance the new power they were giving to the courts with Canada's long history of parliamentary sovereignty. It was their way of making sure our elected representatives still had a final, though very limited, say.
So, the notwithstanding clause really forces us to ask a tough question. Is it a dangerous loophole, a bug in the system that lets governments trample on our rights? Or is it a vital democratic feature, a kind of safety valve that ensures that in the end, our elected representatives, and by extension the people, have the final say? That debate is just as alive today as it was back in 1982, and understanding it is really key to understanding Canada itself.